Hey everybody, Todd Vandermine back again for another edition of Freedom Steel, and we've got some breaking news after this. All right, everybody, Todd Vandermine back again for another edition of Freedom Steel, former NRA contract lobbyist, Illinois gun law guru, and the First District Court of Appeals has issued a decision in my challenge to the Cook County ammo and gun taxes. So, cue the alert. Well, there you have it, guys. So today, the First District Court of Appeals found that the dismissal of my case challenging the Cook County gun and ammunition tax was wrong, that the lower court erred in the way that it treated the case. So I'm going to read to you the closing out paragraph before we get into the weeds a little bit. The county itself has repeatedly and continuously characterized the cost imposed on retail purchaser by the ordinance as a tax, not a fee. The ordinance is called the Cook County Firearm and Ammunition Tax Ordinance. And it is located in the chapter of county ordinances for taxation rather than the chapter for fees. The preamble to the ordinance explains the county levies the tax under its taxing authority, which it explains authorizes it to impose and collect a tax on the sale of firearms and firearm ammunition within the county of Cook. The preamble, more fundamentally, according to the record, the tax imposed here does not have anything to do with the costs associated with the licensing or permit issuing program, nor is it in any way designed to defray administrative costs arising from such a program. The Supreme Court and the other federal courts have sanctioned fees pertaining to firearms such as application processing fees, permitting fees, and other charges that are targeted to recoup the cost for administering lawful Second Amendment regulations. The taxes here aim to raise revenue to fund the county's gun violence prevention programs with no connection to the administration of any regulation. The taxes are imposed exclusively for revenue purposes to fund the county's policy objectives and priorities, and the revenue is not used to cover governmental costs incurred while regulating the act of purchasing a firearm. Accordingly, the tax cannot be continuanced as a permissible fee and can be a fee that can be assessed to a person in conjunction with that person's exercise of the Second Amendment rights. Therefore, the complaint cannot be dismissed on this basis. So, the Court of Appeals found for us on all matters. They found for us on every challenge of standing. They found for us in this thing is to the county's taxing authority, and they sat there and just didn't buy a single one of the county's ordinances. That last part was relating to that the county tried to point to a footnote in the Bruin decision about fees and the like, and the court here didn't buy it because that's not how this is. Now, that's not to say that they may not try and go back another time and rewrite the ordinance. Anything is possible because they've already done that once before. Now, I think that some of these judges might actually follow Mark Smith at the Four Boxes Diner. And I will give a shout out to him here because when they talked about our Second Amendment claim and the shall not be infringed part, here's where the court chastises the county a little bit. Although defendants rely upon Samuel Johnson's dictionary and claim that, quote, infringe means to violate or destroy, they left out Johnson's definition was, one, to violate, to break laws or contract. Two, to destroy, to hinder. A Dictionary of English Language and Digital Edition by Samuel Johnson. Infringe, last visited in January 15, 2024, emphasis added, The Fourth Circuit Court of Appeals recently addressed the scope of the breadth of what infringe means for the purposes of the Second Amendment in the course of striking down Maryland's handgun qualification license regulation in Maryland Shall Issue v. Moore. The Moore court explained that under the first step in Bruin, plaintiffs just need to show that the law regulates a course of conduct that falls within the amendment's plain text, i.e. their ability to possess and carry weapons in case of confrontation. In a footnote during the discussion of this issue, the Fourth Circuit compellingly took apart the dissent's position that infringe for the purpose of the Second Amendment only encompasses a complete destruction of the right to bear arms. So where else have we heard some of this? From Mark Smith on that little part that infringe means to hinder, okay? The majority and Moore explained that the dissent's view, which is the same as defendant's view here, was that the person's Second Amendment right is only infringed if the government wholly or effectively bans the individual from possessing or carrying firearms. The majority that a comprehensive review of the dictionary definitions of the time demonstrated that infringe was well understood to include burdens that fall short of complete deprivations. The Moore court concluded correctly, as we see it, quote, the Second Amendment scrutiny is not exclusively reserved for laws that wholly or effectively prohibit firearm possession. The Second Amendment guarantee, of course, forbids destroying the right, but it also forbids lesser violations that hinder a person's ability to hold on to his guns. Accordingly, we reject defendant's contention that the plaintiffs have failed to plead facts showing that the ordinance could infringe upon the right to keep and bear arms. Bing, 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 as Mark Smith would say. There you have it, boys and girls. So the long and the short of it is we are back in front of the trial court. We will see what the trial court wants to do and how they choose to slow walk this thing through the process. It would also be noted that the appellate court here reprimanded the district court because of their reliance on the Supreme Court, saying it only threw out part of the first district's law ruling previously when it in fact had vacated everything, and no part of the previous first district ruling under Gun Saves Life on this taxation issue is binding in any way and is of no value. So there you have it. We've got another win out today. We live to fight another day. And so as always, thank you for the likes, the subscriptions, copy and paste, share this information around with all your friends and everything. And for those that have stuck around to this late in, my wife is doing better. We are working on getting her discharged to a different rehab facility. It is going much better than we could have thought. She still has a long way to go, but all your thoughts, prayers, concerns, messages, well wishes are all greatly received. So with that, as always, guys, frag out.